Welcome to Atlanta Estate Planning with Terry McGinn.
Welcome back to Atlanta Estate Planning with Terry McGinn. Terry is an estate planning and probate attorney based in Marietta, Georgia, helping individuals and families put clear, practical plans in place to protect what matters most. I'm Shamika Rhymes, and today we're continuing our conversation about what happens in estate planning consultation in Georgia, focusing on the key decisions clients make around healthcare and financial authority. Welcome back, Terry.
Hi, Shamika. Good seeing you again.
Good to see you. Well, let's talk about this, Terry. What are the next major decisions clients need to make after you've gathered all the information that you need for their estate plan?
Well, the next decision the next step goes into me preparing what's called an advance directive for healthcare. And we used to call that a living will in Georgia. A lot of times the living will, where the subject matter in this separate statutory form was included in most of the older wills that I see. Now, the prevailing best practice procedure is to have this as a separate form. It's created statutorily under Georgia law that specifies three things, has three functions. Number one, after I die, how do I want my remains to be treated? We'll get into that in a second, I'm sure. Number two, the second function is if I'm in a coma and I'm terminal, in other words, I'm wheeled into the hospital emergency room and I'm in a coma and the doctors have told my family, old Terry's gone. He's not going to make it to Memorial Day, a couple of weeks, and he's gone due to his injuries or his disease, but I'm in a coma. What kind of intensity of end-of-life treatment preference do I want now that I'm near death but I can't speak? This form attempts to accomplish that for my family, for the benefit of my family, and also to inform the doctors. The third thing this form does is, if I'm in a coma but I'm not terminal, we're having a lot of fun talking about this stuff, right? It's tough stuff. So if I'm in a coma but I'm not terminal, who would I like to be appointed my guardian, or technically the word is guardian ad litem, to be able to act as my legal adult until I either pass away or I come out of the coma. So that's what this form does. The other form that I have in my normal package is called a general durable power of an attorney form, and it's a pretty simple form. It basically deals with who am I going to entrust to do financial transactions for me of all kinds if I'm unable to myself conduct, buy, sell property, do financial transactions like that. So those are the two other documents in addition to the will that I prepare that I normally offer standard in my standard will package.
Okay. Well, to continue this fun conversation, one, one one of the first things that often comes up is choosing a healthcare agent. What role is that person actually stepping into? Because I know when I had the conversation with my parents, I was like, "Are you sure you should pick me?" you know, I don't know if I'm old enough.
Well, what I'm going to do, that's right. So I'm going to look at the statutory wording that's part of the form,
Okay.
and I'm going to go ahead and outline that because these encapsulate pretty well what the obligations and duties are of the healthcare agent. So the first thing is I'm going to read, but the first duty of the healthcare agent is to make decisions for me when I'm unable to communicate my healthcare decisions. That's kind of what we talked about. So if I'm incapacitated, the person I'm nominating is going to speak for me, as evidenced by my decisions in this form. The second thing is I'm going to give to my healthcare agent the authority to make healthcare decisions that I could make, but I'm unable to now. So that's essentially you're becoming an agent, a real agent for this person pertaining to healthcare matters. Again, if they're unable to communicate those wishes themselves. The healthcare agent's got the power under the statute here to admit me or discharge me from any hospital, skilled nursing facility, hospice, or other care facility or service. That's a pretty broad power, but again, I underline, If you are terminal or but you are able to speak, you're able to talk. This is in the event that you're incapacitated, can't speak, or you want to designate this to your healthcare agent. And that happens a lot. I don't want to make that decision. I want to turn it over to my son John or my daughter Jane or my son Mark to do. Request, the other thing they've got is request consent to withhold or withdraw any type of health care. So again, they're in control of what the procedures are and what procedures I've told them in advance I don't want to happen if I can't say that. So that's basically a large general overview of what the statute specifically grants the authority to the healthcare agent. The healthcare agent under the statute, however, does not have the authority for psychosurgery, sterilization, treatment, or involuntary hospitalization for mental or emotional illness. So that's a specific designation that the statute recognizes needs to be adjudicated if this person is unable to do that themselves. So there's limits to what the healthcare agent can do in Georgia under this statute.
Okay. Well, you also have clients named backup agents. What problems do you see when people don't think through those secondary choices?
They pick, it's an easy question. It's a good question. It's easy to answer because I see it a lot. They need to buy into, they want this liability. When last time we spoke, I said that these agents, these fiduciaries, have a legal and personal financial obligation if things go wrong. Same thing here with the healthcare agent, okay? And mainly, you designate somebody, maybe a sibling or a child who doesn't want it. They don't know about it. They weren't told about it in the beginning. So I recommend strongly that whenever they come into me, you want to make Susie or Janie or Mark, whoever, your alternate healthcare agent. Typically, it's after the spouse. So typically, the main healthcare agent is going to be the spouse. But if you want to make somebody an alternate, that's good to do in an emergency. Just make sure they understand what the duties and, more importantly, the obligations are that they're taking on. Some people don't want that. So what happens if you've nominated somebody to be an alternate and they say, I don't want to do it? That's going to be a problem that the hospital's going to have to probably get somebody to be appointed to be an agent for them. And that's a very awkward situation to be in most of these circumstances.
Wow. Well, when someone gives a healthcare agent authority, and we kind of talked about this, but what kinds of medical decisions are they putting in that person's hands day to day?
Just about every medical decision that you could make for yourself, when you're competent and able to communicate, they will take that responsibility on themselves.
Okay.
Basically all. Now, let me elaborate a little bit on that. But that comes up against the duties and obligations of the healthcare participant, their doctor stating, you want to do this, but I can't do that ethically, or I, as the doctor, don't feel that that's appropriate care. So sometimes there's a butting of heads. More often than not, the doctor wants to say, here's the care that we feel is appropriate for your mom or your dad. The healthcare agent says, I can't make a decision about that. I don't know what to do. So that's why this form comes in, which is helpful, because this gives some specific directions as to how they want or how much direction or care they want, so the doctors can rely on this form if the healthcare agent is unable to or is in disagreement with what's written down here. Hope that answers it.
It does. It does. Well, a big part of that document also involves end of life decisions. Well, how do clients work through choices like extending life versus allowing a natural death?
Right. So that's probably the hardest decision that anybody makes. That's why if I'm talking to some people and it's late afternoon, I I do it over the phone or a Zoom call. I say, after this, feel free to have a glass of wine because you're going to need it, because this is the hardest part of it.
Yeah.
So the statute in Georgia breaks down the intensity of end-of-life treatment care preferences, which is the second function I mentioned originally, into three basic categories. I like to use the Goldilocks and the Three Bears analogy because I love that story. The Goldilocks came in and the first bowl of porridge was too hot. The second bowl of porridge was too cold. The third bowl was just right. That's the basic general treatment regimens or regimes that this statute contemplates. It's artificial, but it's the best we've got here. So the first degree of treatment therapy is when the porridge was too hot. If I'm terminal, and again, I'm in a coma, I can't tell you what I want. I'm marking down that on this one, treatment preference A, I'll call it. I want you to do everything you can to keep me alive, even though I'm terminal, I can't speak. Give me all therapies, medicines, procedures, treatments, and when I die, just let me go. The cold porridge is the opposite of hot. If I'm terminal and I can't tell you what I specifically want, I don't want you to put a feeding tube in me to keep me nourished. I don't want an IV to keep me hydrated. And if my heart stops, do not code blue me. I just want to, don't do anything. So if I'm terminal and I can't make a decision, let me go. The third option, which is really in the middle, the median, is I'm terminal, but I can't tell you what I want. So the only thing that I overridingly want you to do is to keep me comfortable. So that means if the only way I can get pain medication is through an IV, put the IV in. If the only way I can get pain medication is through a feeding tube because my veins are shot or whatever the reason, do that. Main thing is don't do anything heroic, keep me comfortable, and let me ride off into the sunset. So those are the three basic categories that I go over with people, and there's a lot of struggle with, which one do I want, et cetera, et cetera. In addition to that, there's another component here is I know that the healthcare agents, I'm talking about my client saying this, I know the healthcare agents got powers to make decisions for me, but what if I want to make a decision that you specifically said is in objection to, for example, just keep me comfortable, but let me go. Mm-hmm. Is there a way that I can give some authority to my healthcare agent to be able to depart from that? The answer is yes. The form has some documentation check marks that they can use that the doctors will say, even though this is what Terry wanted for his health care, he wanted to be kept comfortable to go, but the family has said, we understand he's terminal, we understand he can't speak, but we would like the chance to have him on a ventilator, for example, another couple of days to see if he comes out of it. And if this is executed correctly, the doctors more likely than not will say, okay. So that's basically what the main issue is there, that there's some flexibility in there, even though the healthcare agents got power to do everything, et cetera, if it goes against the specifics that they want, you're stating as the person giving the power that you want to give some authority to your healthcare agent to depart in this area.
Okay. Well, there's also decisions around organ donation and final arrangements, which we mentioned earlier. But what options are people usually deciding between there?
Yeah. So typically I'm going to give you the vast majority of my clients. So the healthcare agent, that's the first issue we said about the functionality. The healthcare agent's got the power under the statute to order an autopsy. Now, unless one's ordered by the coroner, or there's some other, maybe an insurance, whatever. So unless it's not ordered, the person filling out the form can say, I don't want to give my healthcare agent that power. So they're restricting that power. The second thing is the healthcare agent's got the power to donate your body to science. Ick. I don't want that to happen.
Yeah.
I don't want to be, so they can restrict that power. The third power the healthcare agents got, this is all after you die. I have the power as the healthcare agent under the statute to donate organs. Most people say, I want my healthcare agent to donate my organs. It's on my driver's license. This form takes precedence over that.
That's it for today's episode of Atlanta Estate Planning with Terry McGinn. Between these two episodes, you now have a clear picture of what actually happens in an estate planning consultation and the key decisions that shape a complete plan in Georgia. If you'd like to learn more or schedule a consultation with Terry, visit lawga.com. Thanks for listening, and don't forget to like, leave a review, and subscribe to the show so you don't miss the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.